And we will get started. And Sarah, if you just don't mind letting folks in as they come into the waiting room
I got the
while we
waiting
get
room and the
started.
chat. No worries.
Amazing. Okay, thank you so much.
Hmm.
So, hello everyone. Seeing lots of familiar faces coming in today. And for those that have not met me before, my name is Signe Lynch. I am the McKinney-Vento Education homeless education specialist at the Maine Department of Education. I work on the Office of School and Student Supports team, and we are lucky enough to be joined today with my amazing coworker, Sarah Ferguson. Sarah, do you want to just introduce yourself?
Sure. Hi, everybody. Sarah Ferguson, Office of Special Services and Inclusive Education. I work with state agency programs, which means kids who are touched by DHHS and the Department of Corrections, as well as I coordinate the surrogate special education surrogate parent program, and students who are McKinney-Vento eligible and are unaccompanied homeless youth have the right to a surrogate parent if there's no parent already involved.
Awesome. Thank you so much. And so today, if you are here for McKinney-Vento and conversation about students that qualify for both McKinney-Vento and special education, you are in the right place. Oftentimes in our trainings about McKinney-Vento broadly, we don't get to go down fully down this path of the students that meet both of these federal programs and statutes. So today we're going to be really focusing on the student population that meets both McKinney-Vento eligibility and also is receiving special education services in school. So, like Sarah and I said, we are both from the Department of Education. And when we think about what we do at the department, we really think about those strategic goals that we have in place. And a lot of the work that Sarah and I do here is really thinking about promoting that education excellence and equity for all Maine learners. So I think a lot about McKinney-Vento fitting into that equity for all Maine learners and ensuring that students having housing instability, experiencing housing instability and homelessness are able to access a free, appropriate public education and be able to receive education with their peers. So we're going to talk about resources to make your job easier, whether you're joining us today as a McKinney-Vento liaison, a special education director, a school social worker. I know we have a lot of different folks in the room today. Um, we'll just do a brief overview of McKinney-Vento eligibility and the role of liaisons, and then we're going to talk about that educational surrogate piece and students that meet special education um, services or receiving special education services in school. So just for the sake of time, I'm just going to provide just a brief overview. So I know we have a lot of liaisons, but we also have some other folks in different positions, school positions and community-based organization positions. So McKinney-Vento, when we talk about McKinney-Vento services in school, we're talking about the federal McKinney-Vento Homeless Assistance Act, also known as the Education for Homeless Children and Youth Program. So this was legislation that was first passed federally in 1987. We've had multiple amendments along the way, the most recent being in 2015 with Every Student Succeeds Act. And really, the core pieces of McKinney-Vento are really ensuring that students facing housing instability are able to access school, able to access a public education, and have barriers removed. One of the pieces about McKinney-Vento is that it does require that every local education agency, so what we call our SAUs here, our school administrative units, are have to have a liaison assigned. So someone that is designated as the McKinney-Vento liaison for that school district. And they are the point of contact for referrals that are coming in from classroom teachers, other school staff about students that may be facing housing instability. And so we do have a handy lookup tool on our Maine DOE website that you can put in any town for the state of Maine, and it will tell you who the liaison is for that town and how to get in touch with them. I will say, so we update this relatively regularly. It is pulling information from NEO, so what is input by the school district on the NEO platform, and then we do a manual update of it. So it was updated last week. So if you are on there and you don't see the right contact information, that would be something that would need to be fixed at the school district level because we did just run an update at the end of last week. So McKinney-Vento definition, these protections apply to all of our public school students, pre-K through grade 12, and who lack a fixed, regular, and adequate nighttime residence. So those are our three keywords when we think about McKinney-Vento eligibility in school, is that fixed, regular, and adequate. We do not have aligned definitions of homelessness across various state and federal agencies. So when we talk about homelessness in education, we are using the most broad definition of of homelessness used in federal and state agencies. So really thinking about that fixed, can that student go to the same place every night? Do they have a legal right to be there? And then regular, is it where they can go every night? And then adequate, is that place safe and sufficient for the student? So this is a great way to think about it. So if one of these elements is missing from that student's housing situation, that is something that we're going to ask follow-up questions to determine McKinney-Vento eligibility on. Can that student go to the same place every night, and is it safe and sufficient and meeting that fixed, regular, and adequate definition? Students that qualify could be campers, students sleeping outside, students staying in hotels or motels because they have nowhere else to go. Couch surfing, so that's a big part of McKinney-Vento that isn't always encompassed in other definitions of homelessness. So this would fall into that larger umbrella of doubled up, so that sharing housing due to a loss of housing. Shelters or transitional living programs, any student that's living in a car. This would be migrant students. So migrant students don't automatically qualify for McKinney-Vento, but they often are going to qualify under the housing situations that those families are moving to for seasonal work. So they're working in seasonal agricultural positions, seasonal fishery work, and oftentimes those employers are putting up housing situations, and the housing situation that those families find themselves would be inadequate in many cases. Substandard housing is a huge one for McKinney-Vento. So those are students that may be lacking a vital utility. There could be vermin in the home, so thinking about those students that come in consistently with lice and bed bugs, follow-up questions that we need to ask if that house is not, if the home that they are in is not meeting the basic needs of that child. Overcrowding situations, again, those really get into that doubled up, the sharing housing due to loss of housing. And then that substandard housing, like I said, a very common one that we will see in Maine is the lack of a vital utility. So not able to heat the home appropriately throughout the winter, or using unsafe methods, electricity that's been turned off because of back bills, things like that. These are our definitions lined out. And again, like I said, for those that are just joining us, I will be sending out all of these slides for reference. And then also we'll include some attachments of the resources as well, and like the documents that we use for educational surrogate parents and such. And I did want to say, before we jump all the way into the special education piece, if you have questions along the way, Sarah and I really like to just have this be more of a conversation when people have questions. So if you have a question, please just raise your hand, come off mute, and we can answer the question in the moment. Or throw it in the chat, because Sarah is watching the chat right now. So a big student population that comes up, particularly when we're talking about this cross-section of special education and McKinney-Vento, is students that are considered an unaccompanied homeless youth under McKinney-Vento. So this is specifically our students that are not in the physical custody of their legal guardian, and they lack a fixed, regular, adequate nighttime residence. So those students really need to be not in the physical custody of the legal guardian and meet the definition of McKinney-Vento by being in a nighttime residence that is not fixed, regular, and adequate. There's no lower age limit on an unaccompanied homeless youth. We do have unaccompanied homeless elementary school students. And there's various situations that can cause a student to become an unaccompanied homeless youth, to pick up that determination. Sometimes we see it at the high school level where we see students that have been either asked to leave the home of the legal guardian, or they have made the decision to leave the home of the legal guardian. These aren't youth that are just having, they have an argument with their parent on Friday afternoon in high school and they storm out and they stay with their friends for a couple of nights and they're back in the home. These are students that are really staying somewhere else that's not with their legal guardian. And that situation often picks up identification in the McKinney-Vento world under the category fixed. So the place that they're staying is not a permanent situation, right? They're couch surfing, they're staying in a spare bedroom of a friend, another family member, things like that, someone that does not have legal care responsibility or legal guardianship of that young person. Just a reminder for this group, foster care students are not considered McKinney-Vento. And students awaiting foster care was taken out. So previously encompassed in McKinney-Vento definition were students awaiting foster care. So that could be students, for example, that may have been taken into the custody of DHHS. They do not yet have a foster home placement. They are staying temporarily with a caseworker in a hotel. Those students used to qualify for McKinney-Vento, but as part of Every Student Succeeds Act, they really did build out more provision around foster care students. And so foster care students, so students that have been taken into the custody of DHHS in Maine, are going to be considered foster care regardless of that placement. And every school district does have a foster care point of contact for those students that you're working with. But I did want to clarify that this is not about students that are in DHHS custody, although there are similar rights and services available.
And it's a little confusing, Signe, because we
Mhm.
special ed wrote their laws when they were still considered McKinney-Vento. Um, so we're special, our Maine Unified Special Ed regs have not caught up to that. So we're gonna
Yeah,
have to fix it when we fix Muser.
yeah, absolutely. And just so folks are aware, we are seeing an upward trend, as I know many of you are familiar as you're working in schools and working with McKinney-Vento eligible families and students. We are seeing a dramatic increase of homelessness in our school systems. I will say that some of this is a mix of certainly seeing increase of housing instability, a housing crisis, not people not having a places to go, rent being really expensive, inflation, all of those factors. We also see an increase related to funding that was available for schools to work with McKinney-Vento students and provide appropriate support. So that was really a product of American Rescue Plans from the pandemic relief funding that went out. Specifically had funding for homeless children and youth for schools to be able and state education agencies like the Maine Department of Education to do a lot of outreach and support for the student population, knowing that they were going to need additional support coming back from the pandemic. So there was a mix of those increased resources as well as all of the other factors that are going on in our communities related to housing. Also, so residence type, so this is from all of last school year. So this is just from the federal data. So when you are inputting McKinney-Vento data into your student information system, it's going to ask you to report that into 4 different categories. So doubled up is the most common situation that families find themselves in the state of Maine and across the country. So that's that sharing housing due to a loss of housing. A family receives an eviction notice, they're not able to secure another lease or home for themselves, and they are forced to move in with a friend, another family for a temporary amount of time. They're not on a lease, they don't have a legal right to be there, and they could be asked to leave at any time. The other categories are sheltered, hotel, motel, and unsheltered. Unsheltered really also includes all of those substandard housing situations as well. And then when we look at our main McKinney-Vento student characteristics, you'll see that one, we have a increase of multilingual students these are students that are McKinney-Vento eligible and then also have another identification. So that's that multilingual student, maybe they're a multilingual learner, unaccompanied homeless youth, and then special education. And just for the sake of this training today, special education you'll see is around, 30% of our of our McKinney-Vento students are also receiving special education services in our schools. Schools are offering a multitude of supports for McKinney-Vento students. It's very explicit that schools have that responsibility to remove barriers, including immediate enrollment without required documents, as well as that transportation to the school of origin if they are residing in a school, if their homelessness status results in them having to leave the school catchment area that they're in, can receive that transportation to school of origin through a best interest determination process. And when we think about the funding for McKinney-Vento, I always just like to note, so this is a program that does have limited amount of funding to it. So federally, every Title I school has to have a Part A homeless set aside. Certainly encourage our liaisons to work with their Title I teams to know what that homeless set aside is. We had all of that American Rescue Plan homeless children and youth funds that expired on September 30th. And really, as a result of increases in McKinney-Vento um, eligible students across Maine, we did have our state step in and create that pilot program for preventing student homelessness. So this was $3 million that was allocated into the state budget for the purpose of supporting McKinney-Vento students and also prevention. So hoping that students don't pick up McKinney-Vento eligibility by supporting them up front and also supporting schools by having access to some additional funds to support McKinney-Vento programming. And then we have our McKinney-Vento subgrants. We have very few. We only have 7 SAUs that receive those McKinney-Vento subgrants, and that's the federal funding that the state of Maine receives annually for McKinney-Vento purposes, and we are currently in a 3-year grant cycle that just started this year. Time frame for McKinney-Vento. So once that student picks up McKinney-Vento eligibility, they will maintain that throughout the entire academic year in Maine. That really goes through June 30th. And then our McKinney-Vento liaison teams are going to be reaching out to all of those students that they had on their list the previous year to ensure that either the student is to check in to see what the housing situation is for the start of the school year. So has the family found stable housing, or do they remain in a situation that is McKinney-Vento eligible? There is no timeline, so you can't just be McKinney-Vento. If you're McKinney-Vento eligible for a couple of years, it doesn't expire. You could be McKinney-Vento eligible your entire school career. We hope that's not the case for students, but there is no time limit on McKinney-Vento eligibility. So before Sarah jumps in, I think it's really important to look at some of the statute piece because both IDEA and McKinney-Vento are federal statute that have really clear definitions, right? And so when we talk about McKinney-Vento, particularly when we're talking about our student population that is bouncing around, they are not always residing in the school catchment area of the school of origin, and we are talking about transportation and making best interest determinations of where that student should attend school. It's just really important to know. So the school of origin means the school that a child or youth attended when permanently housed, or the school in which the child or youth was last enrolled, including a preschool. When we talk about enrollment, sorry, I thought I had my other one little piece, but I will just say it out loud. But when we talk about enrolled, enrolled is also defined in McKinney-Vento as regularly attending. So if you had a student that was bouncing around, right, and they've enrolled in several school districts over the past few weeks, it's not the school district that last completed paperwork, but the student actually never stepped foot in the school building and attended a class there. We would really go back to the last school district that they were regularly attending at And if they were not regularly attending anywhere, we would default to where they were last permanently residing and attending. So the school of origin is really where that student was last regularly attending. And then the school of residence is really going to be where that student is residing at night. And they're going to be a consideration and should be looped in on those best interest determinations when talking about a student that has had to relocate from outside of your catchment area that is McKinney-Vento eligible. The school of origin and school of residence, and sometimes when, and Sarah and I will reference this as well, sometimes we talk about school of origin and school of residence, especially if we're talking about a student that might be attending a special purpose private school or something like that. We talk about it as an SAU of residence and SAU of origin because it's easier for us to understand who's responsible for that student. Who's fiscally responsible, who's responsible for overseeing the IEP of that student, who's responsible for the care of that student and the education. So SAU of origin and SAU of residence is something that we'll often bring into the conversation if we're talking through a case with you, and we'll talk about today as well. But
And in this
Mhm.
they talk about LEA, which is your local education. I don't know what the A stands for, but
Agency, yeah.
agency. Thank you so much. So when this says LEA, they're talking mainly about SAUs, but we have lots of different LEAs in the state.
Yep. And so oftentimes that's really what we're referencing when we say an SAU. In Maine, we're in terms of federal statute, when you're reading federal statute, it's going to often just say LEA, which really is just what we call an SAU here. I just wanted to draw everyone's attention to statute and the language that is in statute for McKinney-Vento. So one of the big things that always comes up for students that are residing outside of the school of origin's catchment area, because they might have received, for example, an eviction notice, they go and live with another family outside of your catchment area, and then there's a best interest determination process. And if the best interest determination results in that student remaining in the school of origin, which we certainly default to because of school stability, we need to just be aware that that LEA of origin, so the SAU of origin and the SAU in which the homeless child or youth is living, shall agree upon a method to apportion the responsibility and cost for providing the child with transportation to and from the school of origin. This makes it clear that there really needs to be communication, right, between both these LEAs. Sometimes there is that secondary piece that if there is not an agreement upon the method, that there's going to be the shared fiscal responsibility. So that's where we can default to that 50-50 shared fiscal responsibility. But really that communication and shared responsibility needs to be happening first. What can be done up front? One, to communicate between those two McKinney-Vento liaisons, to communicate between those transportation teams, to find a solution to the transportation. And if there's not an agreed upon method, that's where we go to that shared fiscal responsibility. But that communication is super, super important. And so before we get to the automatic transportation, we really need to have that best interest determination. And this is going to be a big piece of when we're talking about special education students as well, as that best interest determination. And so to the extent feasible, this is our statute, we keep a homeless child or youth in the school of origin, except when doing so is contrary to the wishes of the child or youth's parent or guardian. So we really focus on that school stability. We know school stability is super important for this population and all students. And so we do have that, but we also need to be making best interest determinations for the student. So this is a student-centered decision, and that really best interest determinations occur when a student leaves the catchment area of the school of origin, because there needs to be that communication, and we're going to make best interest determinations that are going to differ depending on the student's age, the student's services that they're receiving in school, how far away that new school district is. There's lots of different factors that we're looking at. And so we default to keeping a student in the school of origin. Communication with the new school of residence is really important. And the school of origin really has the ultimate say in the best interest determination. So if the school of origin is making a determination that differs from what the family or unaccompanied homeless youth wants for their education, it is imperative that the school of origin is providing a written notice of that determination, and giving that family the right to dispute. So that's a written documentation saying, this is why we're making a decision that we think is in the best interest of your child to immediately enroll in this new school of residence. And you can list out the transportation seems unreasonable for the age of the student, all of the reasons why, and it needs to be that written documentation with that notifying the family of the right to dispute that decision. It's a really important procedural step in making best interest determinations. When making those best interest determinations, there's lots of different factors that you look at. And again, this is a student-centered decision. The finances of keeping a student in a special purpose private school or the transportation costs really should be removed from this decision. And you're looking at all the different factors of a student. So the age of the student, the distance of the commute, the student's need for that special instruction. So special education is a consideration of what they might be needing for support and what's available at the school of origin versus the school of residence for that student, the preference of the family or the unaccompanied youth, and also the anticipated length of stay of wherever they have now moved to, as well as the time of remaining of the year. And we always use examples like the determination that you make for a student who is now living an hour away is going to be very different if that student is a senior in high school and has 2 months of school left versus a student that is in elementary school and it's October, right? And so this is where we get into those student-centered case-by-case decisions. Regarding disputes, this is just that piece from the statute language about ensuring that that written notice is provided by the school of origin if there is a decision that is made by the school of origin that differs from the family's preference. And I will provide the dispute form, and you'll have these slides available as well for reference. So now we're getting into our McKinney-Vento and IDEA. So Sarah, do you want me to hand it over to you?
Sure. Sounds great. So everything that I'm talking about is going to be a small slice of students who are McKinney-Vento eligible because they are either receiving special ed services or they are in referral to special ed services. So any student who's McKinney-Vento eligible is going to have a best interest determination. And if they stay in their SAU of origin, this nice flow chart shows that the SAU of origin remains responsible for their education and FAPE. And if it's an unaccompanied homeless youth, then you would think about having a special education surrogate parent if their parent isn't available. And then the SAU, if they remain in the SAU of origin, then the SAU of origin and the SAU of residence would work on transportation. If they're moving to the SAU of residence, then they have the right to immediate enrollment. Sometimes when we talk about immediate enrollment, we talk whether or not attendance is the same as immediate enrollment. And so you would think about, a student with perhaps an hour of resource room daily, there would be no reason to not have immediate attendance and to start school as soon as possible. Some students with IEPs have higher needs and have to, like Signe talked about, going to special purpose private schools. So it might take a little bit longer to, you would immediately enroll and they can enroll in the SAU, but whether or not they can start attending is another question. So thanks. IDEA and McKinney-Vento are concurrent laws, so one does not overrule the other. And what if a student is going to an SPPS? So as with any McKinney-Vento student, the SAU of origin and SAU of residence would make a decision about where they attend. And then that would decide which SAU was responsible for FAPE. And if there are changing SAUs, then there would be a transition IEP meeting to determine if the student remains in an out-of-unit placement, because every SAU has their own resources and their own programming. So perhaps one SAU didn't have the resources and programming for the student, but the new one does. So just because a student is enrolled in an SPPS doesn't automatically mean that they need to stay in one when they change SAUs. So like I said, we're talking about a small chunk of the McKinney-Vento eligible students, because there might be some who are lacking a fixed, regular, and adequate nighttime residence with their parents. And then there would be some who are lacking a regular residence who are not in the physical custody of a parent or guardian. And then there are those who are not in the physical custody of a parent or guardian and are getting special education services. And then they could, the McKinney-Vento liaison could request a education surrogate parent, special education surrogate parent. Here's an infographic that I send out when I assign special education surrogate parents, and it sort of delineates the difference between gen ed and special ed. Anything that comes from a special ed office would be signed by the surrogate parent. The surrogate parent holds all parental rights for any special ed matters. So sometimes when students are unaccompanied homeless youth, they opt to assign a caregiver who might be an adult who might help them, maybe their friend's parent that they're living with or something. And that person could apply to become a surrogate parent, and then we could appoint them. So gen ed, I mean, let's think about gen ed rights. It would be enrollment in school, it would be signing up for lunch, it would be signing field trip forms. And again, special ed rights would be anything that comes out of the special ed office. And then on the back, there is in surrogate parents, there is a little clause about unaccompanied homeless youth. So many unaccompanied homeless youth are in shelters like Preble Street, and it is, you may not assign a surrogate parent who works for another agency that's supporting the youth other than if they are an unaccompanied homeless youth. And then staff of the emergency shelter or staff that's working where they are could be immediately become a surrogate parent until another surrogate parent is found. So if a student moves to Preble Street and has an IEP tomorrow, Preble Street staff could go to the IEP and hold parental rights, and then people would get in touch with me and we would find a different permanent surrogate parent. And this is what the paperwork looks like. There's links on the website, and there'll be links further along in this in these slides so that you could have them. And you would fill those out and you would email them back to me. On the back of this page, we go one more. There's recommendations. So if the McKinney-Vento liaison has people that the student has people that the student would like to have attend, then you can put their names on there, and that will help us in knowing what to do. And then
Sarah,
go
so
ahead.
if you have a youth that picks up unaccompanied homeless youth status because the legal guardian is currently unable to provide care and they have temporarily placed that student with another family member, can that family member fill out this form?
The request form, it doesn't happen usually. This is because this is what's giving us the student information. If this does not come from a school district, and DHHS workers often fill out this form for foster care students because they also have the right to a surrogate parent. But if this doesn't come from a school, then I definitely get in touch with the school and find out you know, more information to determine if it's an appropriate request or not.
Right.
This is the rights and responsibilities of surrogate parents that I send out also. You know, they include being able to review all the copies, all the special ed that parent writes, reviewing copies of evaluations 3 days beforehand, getting their advanced written notice, being informed of meetings that are going on. Your responsibility would be to know the student and to understand what's going on and to represent the child's best interests. And then in the bottom, it's something that some people get worried about, the limits of their surrogate parent. The surrogate parent doesn't have any liability if the student decides to, you know, go do something that's not great. So they don't hold any of their gen ed or regular ed or civil rights for the student. So then we ask that the surrogate parent's name goes in all the parent section of all the special ed paperwork. We do know, you know, that these students are highly mobile, and oftentimes the surrogate parent isn't always informed about when kids are moving around, and it's hard to for the new SAU to know that there's a surrogate parent. So if we just keep the surrogate parent's name in the special ed paperwork, then that can help make sure that the surrogate parent can follow the student around.
I'm just trying to make sure that Sid and Adriana are coming.
Oops, sorry, we have somebody.
Come on Saturday.
Alrighty, sorry about that. Okay. They do have some educational barriers. They might have mobility that prevents timely identification and the evaluation of special education needs. We all know students who have moved in the middle of special education evaluations. And then interruptions of services due to school transfers and a delay of the transfer of records and an absence of a consistent teacher that know them. So those are difficulties. And again, the IDEA does not supersede the McKinney-Vento Act, and a special ed student retains all of their McKinney-Vento rights. These nice question and answers. And again, this we're talking about a private day placement, so that would be an SPPS that we call them in Maine, and moves to temporary housing in a neighboring LEA. Which one pays for the placement? It is the SAU who placed the student in the SPPS. So we're going to default to the school of origin, who we're assuming placed the student in the SPPS. So that is going to stay. If there is a best interest determination that the student should enroll in the school of residence, then again, the school of residence is going to hold a transfer IEP, and that IEP team is going to determine whether or not the student remains in the SPPS or if the new SAU has enough resources to serve the student. Then they wouldn't.
I have a quick question about that.
Sure.
If that's okay.
Yeah, please.
I see the word temporary housing there. If a student, right in the question at the start, if student who is in a private day placement pursuant to an IEP becomes homeless and moves into temporary housing. If
Yep.
it was permanent housing in a neighboring LEA, how does that affect?
Would they be homeless in permanent housing?
Well, no, yeah, they wouldn't. They
So,
would have they would keep their identification for McKinney through the end of the school year. So they would still have that identification, but they would be moving into stable housing that would likely, or we would be considering it would, it would last long.
so is this a student who's highly mobile and has already been identified as McKinney-Vento? And then find stable housing somewhere else? Is that what you're saying? Because if a kid is in stable housing, permanent housing in one town and moves to permanent housing in another town, then that wouldn't be McKinney-Vento, right?
Correct. I'm just, maybe I'm misunderstanding the question a little bit. I was focused on the financial responsibility of the district.
Right.
But I'm hearing that the financial responsibility remains with the district that placed the student into the private day placement program
Yes.
no matter the housing situation. It's like a moment in time thing, or does it just last through the end of that school year? Because then the next school year, they're in stable housing and now which district takes over the financial responsibility? Like, say this happened in May. They secured stable housing in May, summer happens, and then in the fall, which district is paying for that private day placement at that time?
The school district that they are now permanently housed in
Okay.
would be responsible because they would no longer be eligible for McKinney-Vento, and so then they have that option to now they would need to either enroll in that new school district that they're residing in or pursue a superintendent's agreement. I mean, those are really the options, but the expectation would be that enrollment in that new school of residence because that's where they've found permanent housing. And that's also where we go back to that best interest determination. So whoever's overseeing, whatever team is overseeing the IEP placement and FAPE responsibility for the student is the school district that's fiscally responsible for the student, other than that split transportation responsibility and expense. Everything else would be the school district that's the school of origin, the SAU of origin that's overseeing the IEP placement.
Okay, so as of July 1, for this private day placement cost, if that family had secured stable housing and not temporary housing, then that financial responsibility would switch over right then.
They would need to enroll in that new school
gotcha.
district, and that
Gotcha.
would be at a decision that the IEP team in that new school district is making.
Okay.
If they're going, for example, the IEP team might make a determination that they can provide services in-house and don't need to contract out to that same school that the student was attending. Maybe they do find that they're going to have that student continue to attend that same SPPS, and then they are the fiscal responsible, the SAU that's fiscally responsible for it now.
Thank you. Lots of moving parts. Thank you.
Yep. And so Signe and I are here to answer any of those questions. So if that, it sounded like it was a hypothetical, but if it ever comes true and you need some support, we're here for you.
Yeah.
Thanks for asking. Any other questions? Okay. So as Signe talked about earlier, the SAUs would consider when you're making your best interest determination, you would consider, their special educational needs and programming and all those, and the disability and all of that. And would be, easy to make sure that any special ed records could get a little bit faster if you were going to go to the school of residence, you could make some special education faster.
And so just for context, so when we talk about chapter 14 and the education of homeless students, this is what we have in our Maine statute. That's essentially taking McKinney-Vento statute. So when we talk about chapter 14 in Maine, that's essentially McKinney-Vento, and it has been codified by the state of Maine, the federal statute, into chapter 14. Same with when Sarah's talking about IDEA law and MUSER. That is, MUSER is what has been codified as in Maine as this IDEA federal statute, and codified in Maine with all of those provisions, and then adapted a little bit to meet more of Maine's unique educational situations. So chapter 14 is referencing McKinney-Vento and that homeless statute when you look at Maine's statutes related to either our state specific statutes and then our interpretations and codification of the federal statutes that come through. So these are just chapter 14. So section 5 is specific to special education students, and just like Sarah was saying, ensuring that they have all of access to immediate enrollment and all of those things, and as well as the aspects of surrogate parents, and then that consideration of the special education services of the student in the best interest determination. Okay, so we have a scenario. So in this one, there's a 16-year-old who's asked to leave the home of the father, who is the legal guardian, and this happens mid-school year. And at that point, the student is identified as an unaccompanied homeless youth by the liaison because they moved in with a friend from school. So they're in a temporary, a situation that would not be considered fixed. So the father ends up leaving the state of Maine and moves to Massachusetts. The student is also receiving special education services. So the school of origin appoints an educational surrogate parent who was assigned in February of that school year. So in May, the father, who is the legal guardian who now lives in Massachusetts, re-engages with the student and decides to attend an IEP meeting remotely. Would we still consider this an unaccompanied homeless minor? And is an educational surrogate parent still required? Maybe a great question for the room.
You want to put your answers in the chat?
Anyone brave enough?
I would say yes, he qualifies as McKinney-Vento for the entire school year. Yes to unaccompanied homeless youth. Yes, yes, still unaccompanied, yes.
Yes. Okay, awesome. So yes, the student is still not in the physical custody of the parent. The parent still lives, the legal guardian still lives in another state, and the student is still temporarily housed with a friend in that not fixed situation. So even though the communication has reopened, the father is attending an IEP meeting remotely, the student still has that unaccompanied homeless youth status because he is not in the physical custody of the legal guardian and is in a situation that is not considered fixed. But Maine regulations count on parental residence, and can the student be considered a Maine student if the father has now moved to Massachusetts? Any thoughts on this one?
Yeah, what do we think?
This one's always tricky.
Maine, if he is still couch surfing in Maine. Yes, he was left in Maine. Yes, he's McKinney-Vento.
Yeah. Awesome. Yeah.
So yeah, and I just want to say that yes, because he is McKinney-Vento, because yeah, he is not in the he does not have permanent housing, and he's not in the yeah, he doesn't have permanent housing, right?
Yeah. Oh, this is, excuse my acronym, that's GA. We had a different situation in there. I had moved the father to Massachusetts. So
Ah.
he didn't actually go to,
Georgia.
regardless. So
Well, they could
student,
have both moved to Georgia, you
maybe
know?
they're moving to Georgia together.
Yes.
So student plans to move to dad out of state for the summer. If he returns, can he be considered McKinney-Vento again? Yeah, so this one can always be tricky because it's going to depend on what situation the student is moving back to. If he returns and dad doesn't return with him, is there another family member, for example, who is the dad is going to arrange a plan with that will be a fixed, regular, and adequate place to live? So is father going to sign over legal guardianship to another family member who can be responsible for the student back in Maine? But if the student is moving back to this fixed, regular, and adequate place to live, then the student may not be McKinney-Vento, but then they would not be considered a Maine student. So those ones are always tricky. So it always just really going to depend on what type of housing situation they're moving back to in Maine. Because there is a good chance that that student could still be considered an unaccompanied homeless youth if they leave the father in another state, but it's really just going to depend on what sort of arrangement is in place and what that nighttime residence looks like when they return to Maine.
Yes. And I know Signe has a wonderful flow chart to help you determine whether or not they're McKinney-Vento eligible when they don't live with their parents. And Jenny has a great question. What rights does dad still have with decision making for the student? So while a student is an unaccompanied homeless youth, Signe?
So while a student is an unaccompanied homeless youth, so when a student picks up unaccompanied homeless youth status and they are not residing with that legal guardian, the school district has to provide any information to the legal guardian under FERPA. So all of that information, so if this guardian is contacting the school would need to release that FERPA information, but there's unaccompanied homeless youth have the right to enroll themselves in school. It is also explicit in McKinney-Vento statute that schools have an obligation to remove barriers to unaccompanied homeless youth fully participating in school. So this is really a local policies and procedure piece related to how unaccompanied homeless youth might consent to extracurriculars, for example. So sometimes that could be having an unaccompanied homeless youth consent to it on their own. It could be a McKinney-Vento liaison or a school admin signing that paperwork. Really, that would be a decision, a local control decision with your legal team on how unaccompanied homeless youth are able to fully participate in school activities because that is explicit in the statute. And schools cannot withhold information of the minor that they are the legal guardian of if the school is reaching out for information on the student. So the guardian would maintain access to all of the information under FERPA, but the school would not have to proactively be reaching out to the school, to the legal guardian for those things. It's just if the legal guardian is reaching out and wants information on their student, all of that information would need to be released to the legal guardian, but it does not have to be a proactive.
Yes, and in regards to IEP meetings, if a student, if if having your parent at the IEP meeting is a barrier to the student attending the IEP meeting, then districts can work that out. Maybe, talk to the parent beforehand or after, have the parent come for half and the student come for half. And if the student had a surrogate parent assigned, then, again, you're going to make your individualized decision, such as, maybe the surrogate parent attends with the student and then the parent attends at a different point in time, or however you're going to make that agreement work. The parent continues to have the right to all of the information and reports from special ed, but the only person who holds parental consent decision-making rights would be the surrogate parent, if it's a barrier. I mean, if the student wants dad to come to the IEP meeting, then there's nothing to worry about. But
Right. And so I think that's another thing to note too, is that we do want to record on from a data perspective in your student information system students that are considered an unaccompanied homeless youth, purely based on that definition of they are not in the physical custody of their legal guardian and they are McKinney-Vento eligible. But oftentimes we want to have guardian involvement as much as possible. And so when we sometimes have students, for example, some of the youth might be able to get into a teen shelter, but the parents are living in a car or needing to go to an adult shelter. So they've been divided based on their homeless status and the services that are available to them. So those students that may be at the teen shelter would be considered unaccompanied homeless youth under McKinney-Vento, but they are meeting up with their legal guardians every day. They have a close relationship. We still want to record them as an unaccompanied homeless youth so we have an accurate picture of the number of students that are experiencing homelessness without their legal guardian. But if their legal guardian is highly involved, we don't need to go through all of these educational surrogate parent steps and all of those pieces, because the guardian is involved, they have a working relationship, all is intact there. Because we do have unaccompanied homeless youth that are close with their legal guardians. It's just that the situations that they are in have made it so that they cannot be together right there in the same temporary housing situation that they are in.
right, and I am going to now extend my apologies because it is 3 o'clock and I need to go. Signe is going to give you my contact information, and she is pretty well versed in some of these things. So if you have questions, please ask. I think she said she could stay on a little longer. And if not, then she knows how to reach me and you know how to reach me. So thank you for all that you do for these kids who need the most supports because they're not getting them naturally. Have a great afternoon.
Thank you, Sarah. So these are Sarah pieces, but like she covered, so educational surrogates, you can get them appointed quickly. Just please, I'll send out the documentation for that as my follow-up email so you have access to the forms. And this is just related to the notice to the legal guardian, similar to what Jenny was asking about. So in the case of an unaccompanied homeless youth, if the parents have not had their rights terminated, they still have the right to those educational records. But if the special education surrogate parent has been assigned, that is the individual who is required to be at the IEP team meeting and give consent, but those guardians would still have access to those records. And so when we think about strategies for making sure that students that are McKinney-Vento eligible and receiving special education services in school, we really just encourage that communication between the special education programs and the McKinney-Vento liaison, making sure that there's just regular ongoing communication on the policies that are in place at the district level, and making sure that there's regular communication about those students that share both of those statuses. And then reviewing local policies and practices that might present as a barrier to students that are experiencing homelessness and receiving special education services. So really just thinking about reviewing those policies. That's something that we certainly do at the state level, is making sure that we are working through new things that are coming out in user, our unified guidance related to special education and McKinney-Vento, to make sure that this population is able to receive quick and effective services. And we really certainly just encourage team meetings, right? Like making sure that you're having open communication and consistent meeting with all of the folks that are involved in students that are McKinney-Vento eligible, and also the special education team. So really just having a regular cadence of meetings and able to process and resolve complicated situations, because we know that situations that come up, particularly when we're talking about a student that has significant IEP needs, so maybe you are looking at those outer district placements. Those are complicated situations, especially when they have McKinney-Vento status as well, and they're going to require a lot of conversations and thinking through those pieces, all of the moving pieces for that student. And Sarah Ferguson and I are available. We help out a lot on those situations, particularly as they relate to out of district placements. So please feel free to loop us in if you're just trying to navigate who's responsible for what in situations where a student is McKinney-Vento eligible and has a more complicated IEP that might require out of district placement. And then this is
Oh, I'm sorry. I
Oh
just
yeah, no
want to
worries.
point out that I did send you a message about a specific thing. If you could just talk to me about that at some point.
Yes, absolutely. And I did respond to you about that. And we can certainly relate. And yours is specific. CDS is a very unique situation. And as we move forward, and just so folks are aware that we are moving forward, that 619 transition, so that special education and responsibility of FAPE is going to be transitioning to SAUs over the next few years. And as we work through that transition, we will have more trainings that come out about what that transition looks like for that preschool age population as it relates to McKinney-Vento, because preschool is part of school of origin for McKinney-Vento. So that is something important to note. So if you are offering services that are funded publicly for students that are under the age of 5, those students do qualify for McKinney-Vento as well. That's a whole other topic, and we will get into that another day for sure. And so this is my contact information. This is Sarah's contact information. I'm going to be sending the follow-up with all of these slides, as well as the forms that we referenced for unaccompanied homeless youth and educational surrogates, as well as disputes. Is there any questions I can answer for folks before wrapping up today?
I have a question, and I know it might be just a particular case, but maybe others have faced this as well. So in regards to the shared cost, so we have a family that we're sharing transportation reimbursement, and we're each doing half. What happens when their reimbursement is different than ours? They offer 70 cents, and we are 50.
Yeah, this is a great question. So these questions get a little tricky. So one, I think that what I would say the best practice is for situations like that is to just have the school of origin that's providing all of these other services, especially if they're providing one way of transportation, and now the only other option that the other school district is able to offer is mileage reimbursement, is to just have the school of origin that has the closer relationship with the family and has already addressed the other side of the transportation, to just do all of that and bill the school district for it. I do think that that transportation responsibility, especially if there's not that mutually agreed upon shared responsibility. So for example, it's very clear one district is able to do AM transportation, the other school district is able to do PM transportation, to just have the mileage reimbursement be done by one school and school of origin that has the closer relationship with the family and is providing all of the other services, to just have it be the school of origin's responsibility. I think it's much cleaner and easier and best practice to do it that way than have a family have to do multiple mileage reimbursement sheets, one mileage reimbursement for one school district for one way, that's a different mileage reimbursement rate, and then another for another school district. So
Right,
really
and I
just
think this
defaulting.
situation is certainly getting messy because the AM transportation is all set because that's through a bus, but so it's the PM that we're sharing. And then, of course, administration's involved and they're, kind of disputing over that. So it sounds like, I don't know where that's gonna land. Somebody was told through the state, to our superintendent that it isn't, I don't know, that we need to go by what our reimbursement is. So I don't know what to do.